This is estate planning lawyer Michael Pevney. I create estate plans for California families, and in this video we are going to talk about why owning a property jointly with your spouse is bad estate planning. But before that, if you are interested in estate planning information, please subscribe to this channel. If you're in California, you can set up a time to meet with me for free by going to ocestateplanlawyer.com and ask an estate planning question in the comments. So a lot of times in California, we want to avoid probate. We don't want our home to go through probate. Now, for those of you that don't know, and maybe some of you do and have been through this with a parent or a grandparent, probate in California is very costly, it's very time consuming, it's not private, it's a public process, and it just sucks. It's the government and courthouse controlled asset distribution program that your estate has to go through if you pass away without an estate plan at all, or you pass away with a will instead of a trust. Now, one of the ways to avoid probate is to own a home jointly with your spouse. So if a married couple buys a home, typically when you buy your first home and you're married, you buy it with your spouse as joint tenants. And that specific term, joint tenants, has a something associated with it called a right of survivorship. So if my wife and I buy a home, we buy it as husband and wife. The right of survivorship means that if one of us passes away, the other one just owns the entire thing. The person that passes away just kind of falls off, and the other one owns the entire home. It doesn't have to go through probate at all. And if you've got just two people, yes, that can be an effective way to avoid probate. But it is bad estate planning, and here's why. First, people die when they get older, and some people are incapacitated, meaning they don't have their full mental faculties available to them. So if my wife passes away and I still own the property and it's owned jointly, and I'm incapacitated and I have dementia and I don't have my full wits about me and I want to sell that home, that might be a difficult thing to do, especially if I'm not able to sign a contract for myself. So if one of the spouses, if the surviving spouse is mentally incapacitated, mean they don't have the testamentary capacity to create a will or to create an estate plan, they can't do it. That just means that that home is going to have to end up going through probate, which is the whole reason we did this in the first place, because we want to avoid probate. Number two, if both spouses die together or within a very short period of time, then the kids or whoever you leave behind are left having to go through probate, which again completely defeats the purpose of avoiding probate while incapacitated. Number three, it's just irresponsible. You're just leaving your surviving spouse, you're leaving your husband and wife to have to deal with this without you. You can't talk about it, you can't figure out who you want the home to go to, and it's just kicking the ball down the road, leaving it for them to deal with. And by the way, when you're gone, your other spouse, they might not be fully legally incapacitated, but they might be grieving, right? They might be going through a very tough time. They've just lost their spouse. And now they have to go out and find a lawyer and figure out what they want to do and figure out how to split things up among the kids. And they have to do that maybe with the help of a lawyer, but they need to do it without you, without the person that left them behind to handle it on their own. So to leave a surviving spouse while they're grieving to set up their own estate plan, because remember, if they don't, when the second spouse dies, you have now died without an estate plan at all, and you're leaving a huge mess behind in order for those you leave behind to clean up. If you've got 3 kids, your spouse dies, and you don't have an estate plan, when you pass away, it's going to have to go through probate. And this can lead to very messy situations. So here's an example, right? You have one kid that still lives in the house and wants to live in the house for as long as they can, and they just want to keep the house. You have another kid that lives close by, maybe they're a little bit more successful, and they have a family of their own, and they want to use that home as a rental property. And they want to collect the income and split it up between the 3 kids. And the third kid lives across the country, doesn't want to have to deal with running a business, doesn't want the other kid to live in it for free, and they just want to sell the house and split the money. Well, what's going to happen? Well, guess what? All 3 kids are going to have to own that jointly and they're going to fight about it. And that's going to cause a lot of strife, and they're all going to eventually have to agree on what to do. One kid might have enough money to buy the other kids out, but the one kid wants to still live there. It's creating a huge mess, which is why just owning a piece of property jointly is bad estate planning. In fact, it's pretty much the same as not having an estate plan at all. So please get that estate planning done. If you have any questions about this or anything else related to estate planning, leave them in the comments. And for those of you in California, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. Subscribe to this channel for more estate planning information, and thank you for watching.